let's understand CPA Act, the remaining part. We have already seen the definition, the objective, the motive, the formation of commissions, district, state, or national. We have seen CCPA, Consumer Protection Council, authorities, their procedure, process, their power, punishment. We have seen lots of domain of public awareness, consumer support. We have already understood in last session about district commission, national commission, and state commission. Let's go further to understand few more aspects of a CPA Act which is newly been added. In that domain, the new chapter which is added under the CPA Act, which was not in earlier act, was a mediation chapter. Mediation chapter was one of the great thing which was added in these act because it made a life easy for many of the people. Because in majority of cases, we have found that there is a out of court settlement. And in spite of doing out of court settlement, still there is a chance that complainant can file a complaint on the basis of document is signed saying that you have accepted the negligence and there was no remedies. Secondly, if at all doctor does out of court settlement, the insurance company used to refuse their claim because it is settled by the doctor. Now the new chapter is going to help you all because mediation has become the procedural process of a law. And in layman language, it is as good as in-court settlement. And so beautifully construed chapter, which has really made an easy life for the people, where consumer and opponent both can be benefited. So let's understand the mediation chapter. Mediation is a very, very important part of Consumer Protection Act. What it says, they have already notified, rules are already made under this. They said by notification, there could be a mediation cell to be attached to National Commission and each regional benches. A consumer mediation cell shall consist of such a person. They've given the structure also. What they said, the consumer mediation cell maintain the list of empaneled mediator, the list of cases handled by the cell, record proceedings, and any other information. So they have already given the object of mediation cells. Mediation cells they have brought so that if at all any matter which need to get settled and both the parties are interested in settling the matter, then once it is filed in a court of law, district commission definitely try to settle the matter by their own within a week. And then if there is a hope of settling, they ask both the parties to give a application in writing saying that they are interested in settling and then it is referred to mediation cell. Mediation cell is like an arbitrator who hears both the people, understand both the people, come to a final conclusion where settlement is possible, and then give a report to district commission where district commission passes the order and it cannot be challenged in any court of law. That is the final order. There is no appeal lies after mediation. So this is one of the beautiful move done by the lawmaker. It shall be the duty of mediator to disclose any personal. So they have already binded the mediator. Any personal, professional, financial interest in the outcome of consumer dispute, the circumstances which may give rise to justifiable doubt as to his independence and partiality, such other facts. So lots of binding is also given to mediator. The procedure, what they said procedure, the mediation shall be held in the consumer mediation cell attached to the district commission, state commission. So everywhere there is going to mediation cell, in district also, in state also, in national also. Where consumer dispute is referred for mediation by the district commission or state commission or national commission, as maybe the mediator nominated by such commission shall have regard to the right and obligation of the parties, the usage of trade, and if any circumstance given rise to consumer dispute and such other relevant factor as it may be necessary. The mediator so nominated shall conduct mediation. So it is the mediator which is going to be nominated by the government under the notification. It can be you, it can be I, it can be any advocate. And then his duty has been defined here. Pursuant to mediation, if an agreement is reached between the parties with respect to all the issues involved in the consumer dispute, or with respect to only some of the issues, the terms of such agreement shall be reduced to writing accordingly and signed by the parties so that dispute can be. So the mediation cell has been empowered to settle complete matter also and part matter also. Suppose there is two prayer clause or one prayer clause got settled. For other prayer clause, the case will run. Or if both the prayer clause has been settled, then matter is closed. So depend upon the full or partial, mediator has been empowered to adjudicate the matter or do a settlement accordingly. Then mediator prepare a settlement report and forward the signed agreement along with the report to concerned commission. It could be district, state, or national. Where no agreement is reached between the parties within the specified time, or the mediator is to opinion the settlement is not possible, he shall prepare his report accordingly and submit to the concerned authority. So they have given a power to this mediator to give a report even if there's no settlement happens between the party, in spite of referring to this. The district commission, the state commission, national commission, as case may be, shall within 7 days of receipt of a settlement report pass suitable order accordingly as a settlement of a consumer dispute and disposes the matter. So district commission immediately passes the order and cannot be challenged. Where the consumer dispute is settled only in a part, the district commission or state commission, national commission, as case may be, shall record settlement the issue which has been so settled and continue to hear other issues. And where the consumer disputes could not be settled by mediation, the district commission or state commission, national commission, as case may be, shall continue to hear. Now the rules has also came in 2020 July. The rule very clearly says, when I talk about medical negligence matter and the dispute resolution through mediation, under section 4 of the said rule, the mediation cell has been restricted to do a mediation of medical negligence cases, which is of grievous injury or a death. So death or a grievous injury, if it goes to court, it cannot be referred to mediation cell, because law maker has thought that grievous injury and in death cases, mediation should not be done. So all the cases of death or the case of grievous injury in a medical negligence are going to be adjudicated by the respected commissions, not by the mediation. Product liability was another chapter added this time. Liability of product is any product we purchase. Like if I talk about medical practice, we do purchase lots of product like implant and the X-ray machine or medical instruments and various things. So who are the liable people in such a product if a product is substandard or defective? For the purpose of that, the same chapter has been added in this CPA Act. The chapter should apply to every claim of compensation under the product liability action by the complainant for any harm caused by defective product manufactured by a product manufacturer or serviced by product service provider or sold by product seller. So even the product seller has been made liable in product liability. So the car you have purchased turned out to be defective, then it is not only the manufacturer of the car, but the dealer of the car would be again agent of the car is going to be held responsible in this chapter. So now product liability chapter has widened the scope of bringing such a people under the law. Same applies, but if you have read definition earlier, we were so lucky that at least in definition they have given a benefit to the medical practitioner, and they said any product used by medical practitioner turned out to be defective, they are protected under law. Otherwise, for every implant what we do on a patient, if turned out to be defective, we become equally liable in that. The product liability action may be brought by the complainant against the product manufacturer or product service provider or product seller, as case may be, for any harm caused to him on account of defective product. So all the three people have brought. Now they have defined the product manufacturer shall be liable in a product liability The product contains the manufacturing defect or defective in designing or is deviation from manufacturer specification or does not confirm the express warranty. The product fails to contain adequate instruction or correct user to prevent any harm. So all these things have already been taken care by the law. A product manufacturer shall be liable for the product liability action even if he proves that he was not negligent or fraudulent in making the express warranty of the product. They are liable even if at all they have done it. See how intelligent our lawmakers were. They have tried to protect all the rights of the consumer. Product service provider shall be liable in a product liability action if the service provided by him was faulty, imperfect, deficient, or inadequate, like service provider doctors. Nature, manner, performance. Performance means what we are doing is the operation, which is required to provide it under the law. There was an act of omission or commission or negligence or conscious withholding of any information which caused the harm. The service provider did not issue adequate instruction or warning. The service did not confirm the express warranty. So even the service provider are brought under the purview of Consumer Protection Act. The product seller who is not a product manufacturer shall be liable in a product liability action. So they have tried to protect the liability also. The who are selling, he has exercised substantial control over the designing. He has altered. Let's see the product has been sold by him. An identity of the product manufacturer of such product is not known, like Chinese product. Or if known, the service of notice of the process of warranty cannot be affected. So many of the product or service providers are not known. In such a cases, they are also responsible. So product liability is going to be on seller also with the new law. Now, exception to product liability action. Who are the exceptions who have been out? A product cannot be brought against the product seller if at the time of harm, the product was misused, altered, or modified. So if it reaches to you and it is already altered, then you are not responsible. A product liability action based on a failure to provide adequate warning or instruction. A product was purchased by an employer for use of workplace, commercial product, and the product manufacturer provided warning. The product was sold as a component or a material. So lots of protection has been given to product seller also. So product liability definition we have already seen. Product liability itself is a ground for filing a case. So instead of a deficiency in service or defective product, they have added one more chapter as a product liability. And under product liability, we can make anyone as a party who manufactures, who distribute, or who sells. Now, what are the offenses and penalties? Whoever failed to comply with the direction of a central authority, we have seen CCPA under the section 2021 shall be punished with the imprisonment for term which extend to 6 months or with the fine which may extend to 20 lakh rupees or it both. So CCPA has been empowered to look after the misleading advertisement, look after the product, look after the duplicate product or spurious product or a poisonous product or a warning which has not been, lots of power has given to CCPA. And CCPA is also empowered to give punishment. And punishment now also been empowered to them to give in the form of a jail. So 6 month jail punishment with a 20 lakhs rupees penalty. Any manufacturer or service provider who causes false or misleading advertisement. Like in medical practice, you will find lots of our clients are doing advertisement. Health sector is now on advertisement. You go to cosmetic domain, you go to dental domain, you go to any domain. Lots of advertisement you will see on the social media to attract the patients. Now, what law says? Any service provider who causes a false misleading advertisement to be made, which is prejudiced to the interest of a consumer, shall be punished with imprisonment of a term which may extend to 2 years So for misleading advertisement, it was not only a 10 lakh and 50 lakh rupees penalty, but also 2 years jail punishment, and with five, which may extend to 10 lakh rupees. For every subsequent offense, is punished with imprisonment for term which may extend to 5 years, with a fine which may extend to 50 lakh. The friend, misleading advertisement is very heavily taken under the CCP Act. And if you have heard me many other time, I shared my experiences. Now criminal action is also being brought under CP Act as the civil court. This court is also going to work as a criminal court for giving a punishment. So this is very important for you to understand so that you can really protect your client, because lots of advertisement we see, I say even ambiguous advertisement like up to 80% is going to be actionable. You claim, like I'll give example, robotic hair transplant. What message it gives to the people? That there going to be a robot who is going to do hair transplant, and then human is doing hair transplant. Tomorrow, if such a patient goes in court of law, what difference lies with you? So you need to be very careful what type of advertisement, who is advertising, what they are claiming, how they are claiming, how it is misguiding or misleading. Everything is going to be very important, and greatest support to consumer under this act, that consumer, even if they are not a direct patient of a doctor, I'm just giving a medical example, then also he can file a complaint. So 130 crore population can file a complaint on the misleading advertisement.